Guys, today we're stepping into a case that looks friendly on the surface but hides serious legal danger. One hearing, one judge, and a life-altering decision is already in motion.
Okay, and good afternoon, Miss, is it Trinell?
Charnel.
Charnel, all right. And date of birth, December 16th, 1982?
Yes, sir.
All right. So, ma'am, we're here today for what's called a preliminary domestic violence probable cause hearing. What that means is there's been no charges filed against you. Today's hearing is simply to decide whether the prosecutors have what's called probable cause, which is the lowest standard of proof, but it essentially allows the court to set release conditions. And for the next 72 hours is the time in which the state has to actually file charges against you. So all we're doing today is determining that. And if there is probable cause, what those conditions of release would be. All right. So Mr. Stashevsky, back over to you.
Your Honor, I met with Ms. Charnel this morning and we reviewed the constitutional protections that apply throughout this process. And I do believe my client understands those constitutional protections. We are seeking the appointment of Thurston County Public Defense, and I do believe that Ms. Charnel should qualify statutorily, Your Honor. It's been represented that she is in the process of applying for Social Security disability and does not have a secure, reliable source of income at the moment, Your Honor. And then for the purposes of today's hearing only, defense is not contesting probable cause.
Okay. All right. Thank you. So, Ms. Charnel, what that means is, so this probable cause has been established, so the court can set release conditions. And I'm also noticing on Zoom there, Ryan Stubbins. So I see you there, sir. See you trying to unmute. No need to address the court just yet. I just want to let you know I see you there. And if you wish, you don't have to say anything, but I'll give you a chance to speak if, okay, all right, see you there. All right, so what we're gonna do now, Ms. Trinell, is set release conditions, and I'm gonna start with recommendations from the prosecutor, and then I'll turn back over to Mr. Stashevsky to speak on your behalf too, okay?
Your Honor, the state would ask for $10,000 bail with conditions of no new law violations, no firearms or deadly weapons, scram device, and a no contact order. The basis for the scram request is that alcohol was involved in this incident. The basis for the bail and no contact order is that the state has concerns based on the facts of the police report. The defendant hit the victim several times in the face during an argument. Additionally, looking at the defendant's criminal history, there's been a number of assault charges. Yes, some have been dismissed, but there's also some guilty findings throughout her history. So the state has concerns on based on that as well, and that's kind of the basis for the bail request.
Thank you. All right, Mr. Stashevsky.
Your Honor, I may first defer to Mr. Ryan Stubbins if he's choosing to make a statement today. I'm not sure if he articulated that.
I would like to make a statement.
And Mr. Stubbins, before you do so, we want to, for today's hearing, we really want to confine comments to entry of a no contact order and those other release conditions that the prosecutor mentioned. This isn't the opportunity to talk about the allegations, what happened, what didn't happen. That's not the point of today right now. So again, you're welcome to speak, but we're just focusing on those release conditions. So go ahead.
Yeah, I have no concerns about Angie being released. This is unusual behavior for her. It's never happened before. I've lived with her, spent every day with her for the past 2 years, and we don't drink. There's not been alcohol in the house. We went to a Christmas party and a white elephant gift got given, and unfortunately it was allowed in the house, and yesterday she drank it, and it's unusual behavior. She's never done anything. She's never done anything to hurt me. She's a wonderful human being, loving, caring, and I don't care what the other allegations are. I know what I've experienced with her, and yesterday was completely out of character. I'm the sole provider. I am disabled. I work part-time at the Freedom Foundation, and if $10,000 bail is put on, it's going to tank me financially. And I want to do anything I can to help her. I'm willing to go to counseling, whatever she needs to help her through this. We just got engaged at the Masonic Lodge on, right after, before New Year's, and it's unfortunate that this happened, but she's not a danger to society, to me, to anyone. And that's all I have to say.
All right, thank you. Mr. Is it Stubbins or Stubbins?
Stubbins.
Stubbins. Thank you for those comments. I'm also curious on if she were released, if there was the entry of that no contact order, so she was out of custody. If you could speak specifically to her not being able to return home.
No, this is the only place she has, and it's her home too. And I do not want a no contact. I do not support a no contact order. I believe, given the proper professional help and assistance, that we can move through this and get back on the track to living life.
Thank you. All right, Ms. Shrinell, do you have any other friends or family in the area if there was a no contact order where you could stay?
Your Honor, she has related to me that while it would present difficulties, that she could live.
Emotions flood the courtroom. The fiancé defends her, talks love, money, and engagement, and paints a very different picture than the police report.
With her mother on Steamboat Island Road, were the court to enter a no contact order. With that statement, defense would just highlight Mr. Stubbins' comments of the isolated nature of this incident in relation to his experience with my client. And I have additional information in relation to the state's request, but I will hold on that until appropriate, Your Honor.
Okay, thank you. All right, and then is Mr. Stubbins the sole provider?
Yes, he is my sole provider. And he has been for the last year and a half.
And do I recall, do the two of you have children together?
We do not.
No children, okay. Mr. Stashevsky, did you say you had more comments, additional comments?
Your Honor, defense wanted to provide a full record for why we don't believe bail is appropriate in this circumstance. Your Honor.
Well, you can. I'll save you the time there, Mr. Stashevsky. I'm not going to impose bail in this case. I am going to impose a no contact order, though, at this point. I'm going to allow an exception for direct written electronic communication for household finances. So the two of you will be able to communicate electronically. So that means written electronic, so text, emails, that sort of thing, to discuss finances, to make sure that that you're able to communicate that way. But I do, having reviewed the police report myself, as well as I'm cognizant of Ms. Shrinell's DUI history as well, and the level of intoxication that's alleged in this case, I think a scram device is also appropriate. So I think, Ms. Shrinell, you're going to be on some pretty significant pretrial release supervision, and I think at that point that satisfies the court at this point that that's the least restrictive means, short of bail, that will keep Mr. Stubbins, safe, the community safe, and keep you sober, because that's going to be conditions of release. So I'll release you. Conditions of your release are to have no criminal law violations, to not go to any bars or taverns, to not consume any alcohol, marijuana, or non-prescribed drugs, to not possess a gun or a deadly weapon. Again, you're going to be on what's called pretrial services supervision. There's paperwork you're going to get there at the jail that has a phone number on page 2 of the judgment sentence form you're going to get. That has pretrial services phone number. You got to call them within 48 hours. All right. And they're going to help you figure out how to get, and you'll get all this paperwork at the jail. All right. And they will help you figure out how to get it's called a scram device. It's something you wear on your ankle that monitors any alcohol in your system. So if it registers, they get an alert, and then the court gets an alert, and that could result in bail being imposed or other modifications to your release condition. All right. There is going to also be a no contact order. There's a civil standby. The civil standby allows you to go back to the Rochester residence with Thurston County Sheriff. So you got to call them first. They'll escort you to the residence, and you can get your personal belongings. Sounds like you can live with your mom while this order is in effect. So you'll have to do that. Again, you'll have that exception for written electronic communication just with respect to household finances. And so that order will be in effect. The last paperwork you're going to get is what's called an order to surrender weapons. All right. That's you can comply with that by either, if you have weapons, surrendering those to the Thurston County Sheriff's Department, or if you don't have any weapons, filing what's called a declaration of non-surrender. That's you attesting to the fact that you don't have any weapons to turn over to law enforcement. All right, so you're going to get a lot of paperwork there at the jail. Before I start filling all of this out, do you have any questions?
Yeah, he was asking if you had any questions.
Sir, I would really like to be able to go home. We have a house. I have all my food there. I have all my paperwork, all of my cell phone, my purse, everything. My whole life is there.
And
I need to go home.
And one of the things,
So you will
I'm
be
willing to go to
allowed.
my mom's. I'm willing to go to my mom's for
Okay,
a couple
so
months.
for both of you, so for both of you, what this order says is that Ms. Chernell is not allowed to go within 1,000 feet of Mr. Stubbins' residence. All right, so there isn't a location requirement. So if Mr. Stubbins is residing somewhere else while the case is pending, then she's allowed to go home. So it's wherever you're living at the time. Does that make sense?
Yes.
I will go to my mom's. I'll start getting stuff packed up this evening, and I'll probably be done with that tomorrow. And she can come back to Company Street, and we'll stay away from each other while this gets sorted out.
All right. And just so you're also both aware, the no contact order is imposed now. You are both sides are free to file a motion to rescind or modify the no contact order while the case is pending. And so, Miss Chernell, work with your attorney on that if you would like to propose something. And then Mr. Stubbins, if you want to reach out to the prosecuting attorney's office. I don't believe they have a victim advocate necessarily, but you can talk to somebody in their office too, but there's a template motion to modify or rescind the no contact order that you can always file. And just again, so you're both aware too, typically I don't want to make any representations about a decision, but typically what judges look for in those motions is some sort of new information that wasn't there when the case was pending. So Ms. Chernell, if you're in some kind of treatment program, any kind of affirmative steps that you're taking to, and address any underlying issues there, that's the type of thing a judge looks for making changes to those pretrial no contact orders. So again, not saying one way or another what would happen, but that's the type of thing that a judge would be looking for.
Okay. I'm in the process of looking for a new psychiatrist. I actually haven't had one for the last 3 months. And that could have been why this.
And we don't want to speak to what the allegations are. We don't want to talk about any of that.
All the things you're saying, highly encourage you to tell your public defender who might be able to help you get the documentation you need for that. Okay. Last thing we're going to do today is set your next hearing.
This is the make or break ruling. No bail, but strict controls, no contact, ankle monitor, and a warning that one wrong move ends everything.
Which is going to be an arraignment on Friday or Monday? Monday. Yeah, but I just know sometimes Mondays.
Oh, that's fine.
I'll just do it Friday.
Yeah.
Okay. Well, I want to give the state all the time that they need actually, so we'll do Monday. Yeah. What time? Those are on 1:30, right? Okay. All right. So Ms. Chanel, your next court date is going to be Monday at 1:30. Kind of backing up, like I was mentioning before, you're not actually. Oh, can you not?
Sorry, Your Honor, it's a little hard to hear at the moment.
Oh, okay. I understand. Can you, Mr. Stashevsky, just maybe come off mute when it sounds like the noise there has died down, and I'll keep addressing the case here.
If the court's able to hear us, we can.
Okay. All I was saying was, so your next court date, Ms. Chanel, is the arraignment. So that's going to be Monday at 1:30. Again, kind of stepping back, you're not actually charged with anything at this point. So the state now has 72 hours to file charges against you. And if they do, that will be heard at the arraignment. And that's when your case would formally commence. Okay. Right. And with that, ma'am, you're free to be taken back.
Can I ask a question, sir?
Yes, go ahead.
So is she being released tonight or today?
Yes.
Okay, so I'm assuming she wants to come back here tonight. I'm just trying to figure this out. If she could give me a couple hours, I will have my stuff packed up and I will be out of here and she can come back here. And if she needs any money or anything to come back here, I want to be able to help her get from the jail to our house. So.
All right. Well, how about this? I'll do this. I'm going to write. So the exception to the no contact order says there's an exception for direct written communication, for direct written electronic communication regarding household finances. I'm going to put in housing. All right. I understand what you're saying here. Not to lose the forest through the trees. The issue is that we want to make sure that the two of you are not residing in the same place. So I'm going to write this exception for written electronic communication for housing. So that means you can go ahead and text her, let her know if you're out of the house. And then she'll know that she's okay to return.
Her phone is here, all her stuff. So how about this? I plan on being out of here by 5:30, 6 o'clock.
Your Honor, the jail
I'm
doesn't
not sure
generally-
how long it takes to process and stuff.
They generally release after dinner time, so like
Yeah.
6, 7, I think.
Yeah, I think
Okay.
practically speaking, she'll probably be released after you're gone.
Okay. Thank you.
All right. Okay. All right. Good luck to you both.
Reality fully sets in. Housing chaos, separation plans, and freedom that doesn't feel free at all. Like the video, subscribe to the channel, and we'll see you in the next video.